हमारे कॉन्स्टिट्यूशन के अंदर जो फंडामेंटल राइट्स है इसमें आर्टिकल 21 आई गेस द मोस्ट डिबेटेबल आर्टिकल है, जिसके ऊपर हमारे कॉन्स्टिट्यूशनल असेंबली जो था वो 3 महीने का डिबेट किया था। उसमें ये डिबेट हुआ था कि इसमें प्रोसीड्योर एस्टेब्लिश्ड बाय लॉ रखे या ड्यू प्रोसेस ऑफ लॉ रखे। प्रोसीड्योर एस्टेब्लिश्ड बाय लॉ जो कि अभी हमारा कॉन्स्टिट्यूशन में लिखा हुआ है, ये इसका मतलब है पार्लियामेंट इज पावरफुल। ऑन द अदर हैंड, ड्यू प्रोसेस ऑफ लॉ मेक्स द जजेस पावरफुल, मेक्स द सिटीजन्स पावरफुल। Citizens can go to the court and ask for any law to be reasonable, just, fair, and there should be the principles of natural justice to be followed. With all these things in our mind, so today's video will be a very good discussion on the Article 21. So let's dive in. Article 21 declares that no person shall be deprived of his life or personal liberty except according to the procedure established by law. So, word use हुआ है no person, that means this right is available to both the citizens and non-citizens. एंड यहाँ पर जो वर्ड यूज हुआ है ये है प्रोसीडियर एस्टेब्लिश्ड बाय लॉ, मतलब लॉ में अगर जो प्रोसीडियर दिया गया है उसको फॉलो कर रहे हैं तो फिर आर्टिकल 21 का कोई हनन नहीं हो रहा है। ये था नैरो व्यू जो कि A.K. गोपालन केस 1950 में लिया गया था बाय द सुप्रीम कोर्ट। एक्चुअली जब भी हम प्रोसीडियर एस्टेब्लिश्ड बाय लॉ का बात करते हैं तब वो आर्बिट्ररी एग्जीक्यूटिव से हमें तो बचाता है, लेकिन आर्बिट्ररी लेजिस्लेटिव एक्शन से हमें नहीं बचा सकता। अगर हमें प्रोटेक्शन चाहिए आर्बिट्ररी लेजिस्लेटिव एक्शन से तो फिर हमें जाना पड़ेगा ड्यू प्रोसेस ऑफ लॉ में, जो कि 1950 के बाद 28 इयर्स लगा सुप्रीम कोर्ट को, एंड सुप्रीम कोर्ट ने फाइनली मेनका गांधी केस में ड्यू प्रोसेस ऑफ लॉ को इंट्रोड्यूस किया। अब देखो, जब भी हम ड्यू प्रोसेस ऑफ लॉ का बात करते हैं तब कोर्ट एक प्रोएक्टिव रोल लेता है इन प्रोटेक्टिंग द कॉन्स्टिट्यूशन। ड्यू प्रोसेस ऑफ लॉ में आर्टिकल 21 अकेला नहीं होता है, इसका साथ आर्टिकल 19 एंड आर्टिकल 14 भी आता है जो मिलकर बनाता है गोल्डन ट्रायंगल। इससे हमें ये पता चलता है कि आर्टिकल 21 एक एब्सोल्यूट राइट नहीं है। आर्टिकल 19 पे जो रेस्ट्रिक्शंस है वो रीजनेबल रेस्ट्रिक्शंस आर्टिकल 21 पे भी लागू होगा, एंड ऑल्सो आर्टिकल 14 हैज टू बी फॉलोड बिकॉज दीज 3 आर्टिकल्स मेक्स द गोल्डन ट्रायंगल। मेनका गांधी केस के बाद सुप्रीम कोर्ट ने धीरे धीरे बहुत सारे केसेस में जजमेंट्स देने लगे जहां पर आर्टिकल 21 जो कि राइट टू लाइफ कहा जाता है, इसके अंदर बहुत सारे राइट्स इनहेरेंट होता है, ये कोर्ट ने रिकॉग्नाइज किया। राइट टू लाइफ के अंदर राइट टू प्राइवेसी आता है, जो कि हमारा केएस पुट्टासामी केस 2017 जिसको हम आधार केस के नाम पे भी जानते हैं, इस केस में बोला गया है। राइट टू लाइफ के अंदर राइट टू लिव इन ए पॉल्यूशन फ्री एनवायरनमेंट भी आता है, जो कि केस लॉ से MC मेहता केस, जो भोपाल गैस डिजास्टर केस जो जहाँ पर ओलियम गैस का लीकेज हुआ था उससे भी आता है। इसमें बहुत सारे प्रिंसिपल्स जैसे पॉल्यूटर पे प्रिंसिपल, डीप पॉकेट थ्योरी, ये सारे चीज़ को इंट्रोड्यूस किया गया। अगेन सुभाष कुमार वर्सेस स्टेट ऑफ बिहार में भी ये बोला गया था राइट टू पॉल्यूशन फ्री एनवायरनमेंट इज इंक्लूडेड इन राइट टू लाइफ। देयर इज राइट टू लाइवलीहुड व्हिच इज recognized in Olga Telis versus Bombay Municipal Corporation. It is also known as the pavement dwellers case. Now there is right to speedy trial which is in the Hussain Ara Khatun versus State of Bihar. Actually what happened, there was 69% of the prisoners who were under trial. So right to speedy trial is a fundamental right. Again, right to free legal aid who cannot afford the advocates or the legal aids for their own cause, they are given a right. It is also in Article 39A of the DPSP. There is also an act, the Judicial Authority Act, which was introduced on this behalf. It was recognized in the Hussain Ara Khatun versus State of Bihar. Now, if we talk about right to education, there is from 6 to 14 years of children, there is free education. There is a case law Unni Krishna versus State of Andhra Pradesh. Here, right to education, which is in Article 21A, later introduced in the Constitution, it was recognized. And also, if we are talking about right to life, then we have to go through a several number of cases. There is first case, the P. Rathinam and Union of India 1994. You have to know that in our the Indian Penal Code, Section 309 of the Indian Penal Code, it is saying that attempt to suicide is an offense. But in the P. Rathinam case 1994, it was the first time when the court said that right to life includes right not to live. That is, yes, right to die. So, court is saying that Section 309 is unconstitutional. Suicide is the permanent solution of the temporary problem. So, forcing a man live is a suffering, is the bodily pain of such manner that cannot be treated. Then, if you are forcing a man to live, then it is right next to suffering. So Section 309 was made unconstitutional, but this case law was overruled by the next case law, which was the Gyan Kaur versus State of Punjab 1996. The case law came 2 years after that. So in this case law, it was held that right to life does not include right to die. So section 309 was again said that it is valid and constitutional, because the reason given behind this was article 21 is talking about natural life, while suicide is the unnatural termination of life. Right to die is not included in right to life, which is in Article 21. So 309 was valid, but later on the court felt that Section 309 has to be removed, because if a person is trying to attempt suicide, there is a mental health condition over him. So the mental health has to be addressed. There has come the Mental Health Care Act 2017, which says that if a person is trying to attempt a suicide, he has his mental health in the lowest possible condition. So his mental health has to be addressed. Now the good news is in the Bharatiya Nyaya Sanhita BNS, section 309 is decriminalized. Again, it is very important to talk about euthanasia. Euthanasia, passive euthanasia is allowed, but active euthanasia is not allowed. But passive euthanasia is allowed under strict guidelines. It was that Aruna Ramchandra case versus Union of India 2011, when the Supreme Court allowed passive euthanasia under strict guidelines, and under only certain cases it was allowed. Now, if you are trying to conclude, because this video has become very long, the right to life in Article 21 has a very big list. It has an array of case laws. We have discussed the main case laws, very few, but you have to know what goes down in the list. In the Article 21 list, there is right to shelter, right to health, right to privacy, right to livelihood, right to free legal aid, right against solitary confinement, right to speedy trial, right against handcuffing, right against inhuman treatment, right against delayed execution, right to travel abroad, right against bonded labor, right against custodial harassment, right to emergency medical aid, right to timely medical treatment in the government hospital, right not to be driven out of the state, right to fair trial, right against public hanging, right to road in hilly areas, right to information, right to reputation, right to sleep, right to freedom from noise pollution, right to sustainable development. So these are the rights which are given in Article 21 that are inherent, and the Supreme Court via various case laws has depicted these rights, has recognized these rights. We as lawyers and law students has to go through these rights time and again. As we are the mouthpiece of the society, we have to take a good care of the rights of our clients. And Article 21 is an exclusive weapon for all the citizens and non-citizens and people of India. I personally think that Article 21 gives the state an accountability. the citizen can ask for that accountability via Article 21. What you feel, let me know in the comment section. Thanks for watching this video. Like, share and subscribe to the channel.